Hi everyone, my name's Sarah Taylor and I'm a solicitor in the dispute resolution team here at Davis Blank Furniss. And today I'm going to be taking you through the Section 21 process and procedure. So we'll start off by discussing the basics of the Section 21 notice. All Section 21 notices are governed by Section 21 of the Housing Act 1988. They only apply to assured short-hold tenancies, or ASTs. The vast majority of residential tenancies in England and Wales are assured short-hold tenancies. The Section 21 notice needs to give at least 2 months' notice for a tenant to vacate. And last but not least, the Section 21 notice doesn't need to give a reason for the notice being served, so a landlord can serve the notice for any reason or no reason at all. There are a number of pre-service requirements that a landlord must have complied with before serving a Section 21 notice in some circumstances. So these pre-service requirements only apply to tenancies that were granted on the 1st of October 2015 and onwards. The pre-service requirements don't apply to tenancies that were granted before the 1st of October 2015. The first of these pre-service requirements is to provide an Energy Performance Certificate, or EPC. The EPC must be provided at the start of the tenancy to the tenant, and the landlord must also provide all subsequent EPCs that are generated throughout the tenant's tenancy. So an EPC has a life of 10 years, so if the EPC expires in the duration of the tenant's tenancy, the landlord will need to get a new EPC and provide a copy of this new EPC to the tenant. The EPC must have a minimum energy efficiency rating of E unless there's an exemption. And again, the vast majority of residential tenancies or residential properties won't be subject to an exemption, so their EPCs must have an energy efficiency rating of E or above. The next requirement is to provide a gas safety certificate. Now, a gas safety certificate needs to be provided for all properties that have either gas appliances or gas connections or both. The gas safety certificate should be provided, like the EPC, at the beginning of the tenancy, and there should be a new check done every year and a certificate provided to the tenant every year within 28 days of the certificate being produced. The next requirement is to provide the How to Rent guide. The How to Rent guide can be found on the government website, and the landlord will need to make sure to provide the most recent version of this How to Rent guide, again, like the gas safety certificate and the EPC, at the start of the tenancy. Now, the courts have found that a link to the How to Rent guide isn't sufficient. The landlord must provide either a physical copy of the How to Rent guide or an electronic copy of the How to Rent guide. They can't just send a link in an email. The next requirement is to deal with the deposit and the prescribed information correctly. So if a landlord has received a deposit from a tenant, the landlord needs to protect that deposit in an approved or authorised scheme within 30 days of receiving the deposit. The landlord also needs to provide the prescribed information within 30 days. Now, there are financial penalties for non-compliance with this, so it's really important that a landlord gets it right in the first instance. Next, a landlord must deal with any complaints about repairs or disrepair at the property. A landlord can't serve a Section 21 notice where A, the tenant has made a complaint about repairs, and B, the local authority has issued an improvement notice or an emergency works notice. Next, a landlord must be aware of any licensing requirements that they might be subject to. So if a landlord has a house in multiple occupation, or it's in an area that requires selective licensing, the landlord must have a valid licence in place or it won't be able to serve a Section 21 notice. The landlord must also make sure to deal with any prohibited payments correctly. And a prohibited payment is essentially any payment that is prohibited under the Tenant Fees Act 2019, and the most common example of this is a holding deposit. If a landlord is holding a prohibited payment, they must pay this back to the tenant before a Section 21 notice can be served. Now, once all of those pre-service requirements have been dealt with correctly, the landlord will be looking at serving the Section 21 notice. The landlord first must make sure, can they actually serve a Section 21 notice at this particular point in time? A Section 21 notice can't be served during the first 4 months of a tenancy, and a Section 21 notice also cannot expire before the end of the contractual term of a tenancy. So, for example, if a landlord has granted a 12-month tenancy to a tenant, they wouldn't be able to serve a Section 21 notice until month 10. By the time the landlord served the Section 21 notice, the contractual term of the tenancy will have come to an end. Next, the landlord must make sure that all of the correct information is provided within the Section 21 notice. There's a correct form that should be used, which is Form 6A, that can be found on the government website. Form 6A should be completed by reference to the tenancy agreement itself, so the names of the tenants, the names of the landlord, the property address should all appear in the Section 21 notice as it appears in the tenancy agreement. So an example of where this might differ, maybe the tenant has a middle name that they've used in the tenancy agreement but they don't use in everyday life. The landlord needs to make sure that what it says in the tenancy agreement is what it says in the Section 21 notice, i.e. using the tenant's middle name in the Section 21 notice to ensure continuity. Next, and most importantly, the landlord needs to make sure that the Section 21 notice is served correctly. The landlord will need to look at the terms of the tenancy agreement. Some tenancy agreements will allow service, for example, by email. Other tenancy agreements will only allow service by personal service or first-class post. So the landlord will need to make sure that they've served in accordance with whatever the tenancy agreement says. If the landlord's going to be serving by anything other than personal service, they'll need to remember to factor in extra days for service of the notice. The landlord will also need to be aware of when the notice was deemed served. So I'll run through some examples here. If the Section 21 notice is personally served, it will be deemed served on the day that it is served, provided that that day is a business day. So if it was personally served on a Monday, it will be deemed served on that Monday. However, if the notice was put in the post, the notice will be deemed served 2 business days after posting. So if that notice was put in the post on Monday, it will be deemed served on the Wednesday. The landlord will also need to be aware of weekends and bank holidays, because obviously these aren't business days and can't be included. If a landlord posted a Section 21 notice on a Friday and the following Monday was a bank holiday, the notice would be deemed served on the following Wednesday, because Tuesday and Wednesday would be the business days. So it's really important that landlords are aware of the different deemed service requirements for each method of service and to take account of weekends and bank holidays that might affect those days of service. So I'll now run through some common pitfalls that we see a lot when dealing with Section 21 notices. The first of these is not providing key documents to a tenant before a Section 21 notice is served. So not providing the key documents that I discussed in the prerequisite requirements earlier on can render a Section 21 notice invalid. Now, these can generally be rectified by reserving these documents before a Section 21 notice is served. So as a landlord, if you're preparing to serve a Section 21 notice and you realise that you forgot to serve the How to Rent guide on the tenant at the very beginning of the tenancy, you can put this right by serving the How to Rent guide on the tenant before serving the Section 21 notice. Now, unfortunately, there are some grey areas. So it's unclear whether failure to provide an energy performance certificate at the start of the tenancy will render a Section 21 notice invalid. And similarly, it's unclear whether failure to provide or even get a gas safety certificate at the start of a tenancy will render a Section 21 notice invalid. The law just isn't clear enough in these areas, and that's why it's so important for a landlord to get these things right at the very beginning. Another common pitfall is not dealing with any deposits or the prescribed information correctly. So not protecting the deposit or failing to provide the prescribed information can render a Section 21 notice invalid as well. Now again, it's possible to put these problems right. You can provide the prescribed information before serving the Section 21 notice, but as I mentioned earlier, there are possible financial penalties for doing this. So whilst the notice may be found valid, the landlord may be hit with a financial penalty for failing to serve the prescribed information correctly in the first place. Similarly, if a landlord's taken a deposit and hasn't protected it properly, this can be rectified by returning the deposit to the tenant before serving the Section 21 notice. Another common pitfall is failing to give the correct notice to a tenant when serving the Section 21 notice. Now, not giving 2 months' notice will render a Section 21 notice invalid. There is no coming back from that. So if a landlord wants to serve a Section 21 notice, they need to make sure that they've given 2 months from the date of service, not from the date that the notice was signed. So if a landlord's going to be putting the notice in the post, they need to make sure to add an extra few days for the notice to arrive, especially if they're going to be serving this in a period that includes a weekend or a bank holiday. Now, it's always sensible to add in a few extra days. That could be a few extra days for service and then a few extra days thrown on top just to be on the safe side. Either way, it makes sure that the tenant will have received the requisite 2 months' notice. So you might be a landlord wondering, what can I do now to make sure that the Section 21 notice that I'm about to serve is valid? So first of all, check your calendar. Can you actually serve a Section 21 notice at this point in time? Are you within the first 4 months of the tenancy? Or will the contractual term of the tenancy not have expired by the time your 2 months is up? You need to make sure that you are actually in the period where you can serve a notice before serving the notice. Next, check your documents. See what you served to the tenant when they first began their tenancy with you. See what you'll be able to put right if you forgot to serve any documents on them at the beginning of the tenancy. It's always helpful to get a receipt from the tenant at the beginning of the tenancy to prove that they received the EPC, the gas safety certificate, the house to rent guide, etc. So a few years down the line, if you're serving a Section 21 notice, you can easily prove to a solicitor and to the court that you did comply with all of the prerequisite requirements. Next, check your calendar again. Have you given enough notice? Have you factored in the days for service? Have you considered whether there are weekends or bank holidays involved? Always make sure to add in an extra few days just to be on the safe side before serving the notice. And finally, serve by multiple methods. If your ASC allows you to provide notice by email, do it by email, do it by first class post, do it by recorded delivery, personally serve if you can. Serving the notice by multiple methods will make sure that the tenant definitely received the notice and definitely received the right period of notice. So thank you very much for listening today, and if you do have any questions, please do not hesitate to get in touch with our contact details, which can be seen on the screen now. Thank you.